Hello, and welcome to this week's edition of Tax in 10 with me, Rachel de Souza, and Andrew Robbins. We're both tax partners in RSM's London office and have a wealth of experience in dealing with a wide range of private client matters. Your feedback is valuable to us, so do keep it coming, especially if you have any thoughts on topics you would like us to cover. Now, Andrew, this week I've been reading about a case called Tooth, which seems to have been going on for ages, but has now been decided by the Supreme Court.
Yes, and I promise this is the only pun I'm going to give in this session, but the Tooth case really has been like pulling teeth. It's taken years to get through to the Supreme Court and get a final decision, but it is worth looking at. It's actually quite interesting for a lot of different reasons.
Yes, indeed. So can you give us a brief summary about, what it's all about?
Yeah, so some years ago now, Mr. Tooth was a party to a tax avoidance scheme, which was meant to create an employment income loss that he could set against his other income. The problem that Mr. Tooth had was that there was no particular box on his tax return where he could claim this employment loss. So what he did instead was he stuck it on the partnership pages of his tax return, and he put an extensive, what we call a white box note, an explanation on the tax return, saying what he was doing and why he was doing it.
Okay, well, that all sounds perfectly reasonable. So what was the problem?
Well, the problem started because the scheme didn't work. So Mr. Tooth had claimed tax relief on the losses that he'd expected to be able to recover, but that loss relief wasn't due. So HMRC wanted to assess the tax that he wrongly claimed back. HMRC's problem is that they'd left it too late to raise an assessment under normal time limits. So instead, what they did was raise what's called a discovery assessment. And it's raising this discovery assessment, which is what the Tooth case is really all about.
Okay, so the basic point here is that tax can only be assessed and thus become due if HMRC actually knows about the particular source of the income or the gain or so on. And therefore, a discovery assessment can be raised where HMRC becomes aware of information that would have allowed them to raise an assessment earlier if they had known about it at the time.
Exactly.
But there are rules that govern when HMRC can raise one of these discovery assessments. And these rules are designed to stop HMRC challenging taxpayers decades, for example, after a particular event has occurred. So it's a protection for the taxpayer. In the Tooth case, HMRC had also suggested that there was a deliberate failure to disclose this information about the loss. And under these rules, it means that HMRC have 20 years to raise an assessment from the date that particular event took place.
Yeah, exactly. And on top of that, there is the question of how quickly HMRC should act once they become aware of new information. And the lower courts have come to call this the concept of staleness. And the idea here is that once HMRC become aware of new information, they have to act on it without undue delay. And so the logic that the lower courts were following was that, yes, HMRC might validly make a discovery of new information, but if somebody just sticks that new information in a drawer for 3 or 4 years before doing anything with it, then effectively HMRC lose the right to use the information to raise an assessment. And what's underlying that is the idea that what you touched on, that HMRC shouldn't be allowed to come back and challenge you years and years and years later, even though they could have done that on day one if they'd got their act together.
Okay, yeah, well, that kind of makes sense. So what did the Supreme Court actually decide? And to be honest with you, why do we care?
Well, the Supreme Court looked at two different things. And the first thing the Supreme Court said is all the lower courts are talking absolute rubbish. There is no such thing as staleness. It's just a made-up idea that the judges have put together. You can't find it in legislation. It's just not a thing. So what matters when you're looking at raising a discovery assessment, according to the Supreme Court, is that HMRC become aware of new information, not when they then act on that new information. So Mr. Tooth just comprehensively lost on that point. The second thing that the Supreme Court said was that Mr. Tooth did not deliberately fail to disclose anything. In fact, exactly the opposite. He did everything he possibly could to tell HMRC what he was doing. You know, the Supreme Court basically said it wasn't his fault that the tax return didn't have the right box for him to use to put his loss in. And he went out of his way to put the loss on the tax return in the best place he could find, and then to tell HMRC what he was doing and why he was doing it. So Mr. Tooth won on that point, which means that HMRC's discovery assessment failed.
Okay, but the point here is actually, the important point here is really regarding staleness, because we know that a lot of people have been waiting on the outcome of this case because HMRC have delayed progressing their particular assessments whilst this case goes through the court. So now that has been comprehensively decided and decided in HMRC's favour, we expect, of course, that HMRC will now pick up the pace on all of these inquiries that have been left to lie. The Supreme Court has also been really clear that you can't escape a tax charge just because HMRC delayed raising an assessment they were entitled to raise. And this does seem a bit unfair that any individual should escape paying tax altogether. However, it also seems right that, you know, you can't escape a tax charge that is properly due just because HMRC, you know, has delayed in raising the assessment.
Yeah, I think so. It feels like on balance, this is a sensible result. I think the staleness side of it does feel a little bit unfair that the revenue can now take as long as they like. If they discover something new, they don't have to be competent. They can just stick it away and ignore it and come back to it later. But, you know, speaking as a taxpayer, if tax is due, I want HMRC to collect it however long it takes them to collect it. So you've got to balance the two sides to it, and I think this is probably a reasonable way to do it. The other important thing here that I would add, which I think is relevant to lots of people, relates to how you actually prepare your tax return. It looks pretty clear that if Mr. Tooth had deliberately or accidentally put information in the wrong box on his tax return, HMRC could have made a discovery later, even though they already had the information. So if there had been a box for an employment loss on the return, but he had put the loss in the partnership page, effectively he wouldn't have told the information to HMRC properly, and they could have discovered that later, even though it was physically on his tax return. What saved Mr. Tooth was that there wasn't a box to put his employment loss in, and he genuinely did everything he could to tell HMRC what was going on. So there is an important sort of practical point here. Just because you've told HMRC something, that doesn't mean you're protected from them coming and challenging you later. You've actually got to tell the right person, and you've got to tell them in the right way. So in particular, you can't rely on people within HMRC talking to each other. Just because I've notified one part of the revenue, I can't assume that the whole of HMRC then know what I've told them. It's my responsibility to tell the right people. And if that means I've got to tell 3 different bits of HMRC the same thing, well, tough, that's what I've got to do. So to that extent, I think the moral of the story is that you really do need to complete your tax return completely and accurately to protect you against these really long-term challenges from HMRC. And you can't avoid a tax liability by blaming HMRC delays. And you can't avoid a liability by sending HMRC a disclosure that goes on for 900 pages, and the critical bit of it is buried in page 863. You've got to be clear, you've got to be open, and you've got to talk to the right people.
That all makes sense to me. So on that note, let's turn to our recommendation. And this week, Andrew's got something for us which sounded really interesting when he mentioned it to me earlier.
Yeah, this is a new book called Pandora's Jar by Natalie Haynes, who I've talked about here before, who's a classicist and stand-up comedian. And this is a book that looks at basically women from Greek mythology, telling their stories, focusing on the women rather than the usual way of concentrating on the men. And it's really nicely written. It talks about the original stories, how they've been twisted over time, how the roles of women have been sort of minimized and they've been made to look more guilty as time goes on. It's really fascinating. It's funny, well written, really well worth a look.
Brilliant. I think that one is definitely going to have a dip into. Anyway, thanks for listening. As before, we can be contacted at rachel.souza@rsmuk.com and andrew.robbins@rsmuk.com. We'll see you again next time. Bye for now.
Bye.